everyone. We welcome you to Vidhi Vaani, the Legal Aid podcast series of the VidhiMitra Legal Aid Cell DNLU Jabalpur. My name is Mahak Jain. I am a third year law student and co-convenor at VidhiMitra Legal Aid Cell DNLU Jabalpur. In this episode, we are dealing with the transforming journey of the India's information regime from opacity of the Official Secrets Act to the Right to Information Act. In this episode, we are truly honored to have Mr. Utkarsh Sonkar sir, an advocate at Madhya Pradesh High Court Jabalpur, who has joined us to share his valuable insights. We are truly welcome you, sir.
Thank you, Mac.
Sir, the RTI Act has empowered citizens like never before, giving them a powerful tool to access to information. But before we dive into the RTI, let's start with some historical context. Sir, could you please give us a brief overview of the Official Secrets Act and Right to Information Act and how these two legislations reflects contrasting approach to governance and information to access to the information?
Certainly, Mac. When you consider Official Secrets Act, you would see that it was enacted in 1923 in our country when we were under the British rule. So it was to further a sense of secrecy in governance. Because come to think of it, we were essentially subjects over which the British were ruling at that point of time, and therefore we were considered to have no regard with respect to the way in which we are governed. And hence, secrecy was the norm and transparency was an exception. The change that has been brought about by Right to Information Act, and this began at the advent of our Constitution of India, because we trace right to information in Article 19(1)(a) of the Constitution of India. So that's when this change ushered in and we did away with this regime of opacity that we had. And now transparency has become a norm and secrecy an exception. And a huge moment led to the enactment of Right to Information Act, which was led by the Mazdoor Kisan Sangharsh Samiti. And it has catered in to the needs of people and has empowered them like never before. Because you would see IP Messi has said that information is the live wire which illuminates democracy. And until and unless people have information and knowledge about the way in which they are governed, it can never lead to good governance in the country. Therefore, having this information leads to a situation wherein we eradicate the issue of information asymmetry, wherein people are empowered, they know whom to vote for, they know their rights, they know their liabilities, and at the end of the day, it leads to good governance.
Thank you, sir. So the RTI Act has certainly empowered citizens, but its implementation is not without challenges. So, sir, from your experiences, what are the key challenges that hinders the people from obtaining the information from the government, institutions and authorities?
That's an interesting question, Mahak. In fact, it reminds me of a very funny incident way back in law school. I was at the fag end of my 5th year and I was preparing for judicial services back then. And one of my juniors walked up to me and he was like, how's it going? What are you looking forward to? So I told him about the same. And he suddenly said, oh, Naukar Shahi. And then he paused for a while and he said, no, Afsar Shahi. This actually indicates to you the way government servants are actually perceived in the country. We still have a feudalistic mindset. So whenever you go to any government department asking for certain information, which now, by the way, is a matter of right, to them it appears that they are doing a favor to you at points of time. RTI brings about a change in this very approach. So RTI does not stop at just giving you a right to access information. In fact, the very intention of the legislature is to ensure that all the information which is supposed to be made available to the public should be made available in an extremely accessible format already to them. Now, as far as the challenges that we face, one of the challenges is this feudalistic notion of not providing all the information. Most of the time we see that attempts are made to ensure that somehow or the other, the information that is sought for comes within the exceptions that are provided under the RTI regime. to ensure that it is not disseminated to the people. Now, that's where legal aid clinics can actually become pivotal, because you can help applicants draft their applications in such a clear and lucid manner that whatever information is sought by them is eventually given to them. The second aspect, which is of extreme importance, is that what do you do when you become aggrieved by non-grant of information to you? There is a hierarchical appellate mechanism which has been provided for in the enactment. You can apply for certain information. If it is not given to you, you can challenge the same. However, the issue lies in challenging the same, because when you actually challenge it, the qualification requirements for the members of State Information Commission and Central Information Commission are not that of individuals who actually hold legal acumen and judicial expertise into matters. In fact, the Honorable Supreme Court in a particular matter, that is Namit Sharma versus Union of India, has actually ended up holding that they would read into these requirements of legal acumen and judicial expertise into the qualification requirements of State Information Commissioners and Central Information Commissioners. Unfortunately, this judgment was reviewed by the Honorable Supreme Court itself after a particular point of time, wherein they did away with the earlier proposition. Now, in my personal opinion, this becomes problematic, because most of the time when information is sought, there is a tussle between conflicting rights of the people. You may ask for an information under your right to information, but that may impinge on someone's right to privacy. Hence, a balancing act has to be done at that particular point of time, which requires a trained judicial mind, someone with legal acumen and judicial expertise to do that. If this is done, one of the major challenges in procuring information in a timely manner can be done away with, because the authorities before whom you would agitate your grievance would be well equipped to actually deal with the same.
So what are the major drawbacks of the Official Secrets Act? And could you please share it with some examples, and how does it harmonize with the Right to Information Act, and what is the way forward to it?
Yeah. One of the major drawbacks of Official Secrets Act is that it neither defines a secret nor an official secret. So virtually we are in a situation wherein anything and everything can be defined as a secret and brought within the purview of Official Secrets Act. Another thing is, it does not provide for any mens rea. It's a strict liability offense. So what happens is that the reason behind dissemination of that particular piece of information fade into insignificance. Now we can draw this thing out from an example. Now in UK, there was a case of R versus Ponting, wherein Mr. Clive Ponting, he was a civil servant, and he was charged by the British Ministry of Defence under the provisions of the Official Secrets Act. We have incorporated the same legislation from there, on the ground that during the Falkland Wars in 1982, certain documents were revealed by him to a particular member of parliament, which demonstrated the role of a British submarine in actually sinking of an Argentinian cruiser. His defense to dissemination of this particular piece of information to a particular member of parliament was that the concerned ministers were actually misleading the parliament. However, in the court of law, the judge did not buy this particular legal defense of it. In fact, he ended up directing the jury that Mr. Clive Ponting has no legal defense whatsoever. Only that at the end of the day, by the collective wisdom of the jury, he was held to be not guilty. But this shows you the draconian nature of the provisions. Like, even if you want to further public interest and you disseminate certain information, but just because it is branded as a secret, you may be prosecuted under the Official Secrets Act. Now, interestingly, after the advent of RTI in our country, there is a particular provision, section 22 in that, and it begins with a non-obstante clause. Now, Professor S.P. Sathe has argued in his book that a literal interpretation of the same virtually means that Official Secrets Act has impliedly been repealed. But then he gives a statutory caveat that that implied repeal does not work within the statutory framework of our country. But that shows you the extent to which the provisions of Official Secrets Act can be used in a draconian manner. And there's a need to harmonize the same with the new information regime that we have.
Thank you, sir. So you just mentioned that the intention of the RTI is not just to give the information that is asked for, but the government department should show more to ensure that the information that is not available, they should put it before. So could you please explain it with some examples?
Certainly. As I said, intention of RTI is not just to provide you information that you are asking for. A lot of information that people generally ask for should already be out there in the public domain. Let's take an example. The Honorable Supreme Court had lately directed in a few cases pertaining to criminalization of politics that all the politicians who are going to contest elections should have their affidavits put out in public platforms so that people can peruse the same and then they can make informed choices regarding whom to vote for. The idea is that information asymmetry has to be removed from the system so that people can make informed decisions of their own. Now, classic examples of this having been taken to its logical conclusion is a digitization of land records. You would see a lot of litigation in our country was regarding property disputes. But over the course of years, you would see there's a drop in number with respect to the same. So there has been a huge movement which has been going on regarding digitization of all the revenue records, and they are put up on the websites of revenue departments. So in MP also we have MP Bhulek, which has all the revenue records digitized from 1950 onwards. So today, if you were to purchase property, you can very easily go and trace back the title of that particular property from the revenue documents at least as to who has been in possession of that property. So that significantly cuts down scope for unnecessary litigation. So that's a win-win situation. Not only are people getting access to information readily, which they would have otherwise asked for by asking for certified copies of khasra khatanis and land revenue records, but it is also cutting down on a lot of litigation. And the second example is that of courts of law. You would see accessibility to orders and judgments of the court has now become default. At least if we consider the constitutional courts of our country, the high courts and supreme courts, the daily proceedings and the judgments get immediately uploaded online. So it's very easy to go peruse them and see exactly what happened. Even at the level of district judiciary, most of the district judiciaries now at least upload their final judgments. There are jurisdictions like Delhi, wherein even the daily proceedings get uploaded, but other judiciaries at the district level are also incorporating that into the system. And this truly ends up becoming a game changer for the litigants at the end of the day. Because earlier they had to go to the court, apply for a certified copy of the order, and then get to know what actually transpired in the court on that particular day. But now it has completely changed that aspect. Not only can they have access to the judgments and orders directly online, these days we even have live streaming. So this is actually right to information in its true spirit.
Okay, sir. So, sir, how it will help in access to justice?
That's interesting. Most of the times, Mahak, you would see people don't even know the grievance which they are trying to redress. What RTI does is that it provides you that particular information, usually by which you are aggrieved, so that you can take it to its logical conclusion, that you can go ahead and actually challenge it. Prior to RTI regime, people had a very hard time even obtaining information of which they are aggrieved. Most of the time, they didn't even know their grievance. And once someone doesn't even know their grievance, the question of redressing it does not even arise. So RTI is fundamental to access to justice.
Okay, sir. So my next question is this: how does people's right to access information clash with the right to privacy, and how does the court balance this tussle between the Article 19 and Article 21 right to privacy?
Yeah, so this is a usual dilemma which the courts face, how to balance two rights, and both of them being fundamental rights. One is Article 19(1)(a), that is right to information, and another one is right to privacy, which is drawn out of Article 21. Now, first aspect that we need to consider, and this is something that I am drawing from my previous assertions, is that the body before whom you go to seek the information must have some degree of judicial expertise and legal acumen to actually adjudicate this particular nuanced question. Because you would see both of these rights, though fundamental in nature, are not absolute. They are qualified. There are reasonable restrictions surrounding both of these rights. Hence, a balancing act has to be done, wherein in the peculiar facts and circumstances of each and every case, court will has to see which triumphs, whether dissemination of information triumphs in a particular case or the protection of privacy triumphs in a particular case. And only pursuant to balancing these two can court come to a conclusion as to which has to be upheld in that particular case and whether information is to be disseminated or protected in that particular case. So that being said, your immediate grievance redressal mechanism, that is the state information commissioners and central information commissioners, clearly need to have that judicial expertise within them, because it's not just the question of providing or not providing a particular information which has been asked for, but the very nature of that information and very nature of that information having this intricate tussle of two fundamental rights.
As a legal aid advocates, it's crucial to recognize that RTI is not just a law, it's a tool to access to justice. We hope this discussion has provided valuable insights, not just into the law themselves, but now as citizens we can use RTI to build a more transparent, just and accountable society. Thank you so much, sir, for your valuable insights, and thank you so much everyone for stay tuned to VidhiMitra Legal Aid Cell DNLU Jabalpur.